Welcome to everybody joining us for this really important topic about public defense independence. So I want to give you guys a brief overview of how we're going to proceed today. I'm going to tell you first, we're going to do a little bit of polling. So please go grab your cell phones, get them on. In a minute, we're going to do a little live polling to get some feedback from you all about how you perceive independence and the independence of public defense systems in your state. After that, we're going to do a moderated panel discussion about some of the central issues relating to public defense independence, and then open things up for audience Q&A. And then, like any good trial attorney, we're going to close out with a solid closing argument from each of each of our panelists about public defense independence. Great. So we're going to go ahead. So the question we have for you is, in thinking about your public defense, about your jurisdiction's public defense system, how free are they to do each of these things? Make decisions about staffing and personnel, make decisions about advocacy in individual cases, speak out about public defense systemic issues, so things like budgets and funding and caseloads, speak out about more of the large legal system issues around things like bail practices and policing. And then those, big picture issues, social justice things, racial injustice and immigration policies. We know that across the country, public defense systems look very different, and how defenders are able to work in those systems can really vary very widely across a whole range of factors. And these are a number of the topics we're going to talk about today as we work our way through this conversation, because each of these has a connection to public defense systems and their ability to function in the way that we believe a robust public defense practice should. And so what we're starting to see from folks as folks are working their way through these questions is that, for the most part, we feel like maybe we have, some freedoms in some places and some real challenges in some others. It's always very heartening to see that we feel like public defenders have a lot of ability to make decisions in individual cases, to be able to be effective advocates for their clients. That is their number one most direct responsibility. But as we start to look at some of those bigger picture issues, systemic funding, legal system, what we're seeing from you all is that they often feel that they have a lot of restrictions in what they can do. So I'm going to stop my screen share here, and we're going to kind of use this as a little bit of our launch point for our panel. And I'm going to turn things over to our panel. I'm going to kick off that conversation on public defender independence with Keisha Hudson, the Chief Defender for the Defender Association of Philadelphia and the co-chair of the ABA's Task Force on Public Defense Independence. I'm going to ask Keisha to take a few moments and kind of set the stage for us a little bit about this issue, the ABA's involvement in this issue and why it's so important.
Thank you, everyone. Thank you, Bonnie. Thank you for asking me to be a panelist. I have the distinct experience of having been subjected to termination. I was terminated along with Chief Defender Dean Beer when we were the Chief Defender, and I was the Deputy Chief Defender in the Montgomery County Public Defender Office, and I'll get into that a little bit later. But first, wanted to talk about the work of the ABA Task Force. I think as we saw by the polling, it comes as no surprise that this is a issue that is really at the forefront of the work that we do. The ABA Task Force was formed because of what we were seeing nationwide, threats, not just to me and Dean Beer and what happened in Montgomery County, but when you look at different public defense systems, regardless of how they're constructed or designed, you see public defense chiefs and leaders being fired for advocacy, and that advocacy could look like structural or system advocacy, right? Challenging the way that our system is designed on policy issues. In our case, mine and Dean's case, it was filing an amicus brief challenging bail reform. And of course, there are those here on this discussion who are line attorneys who know intimately day to day from client to client what you can and cannot do or how restrained you may feel in your advocacy. And so the task force was formed in 2024. So it's over well over a year old at this point, and it's chaired by myself and the co-chair is Malia Brink. Comprised of task force members, and also we do have an advisory board. And the purpose of that task force, it's a pretty heavy lift. We are trying to look at public defense systems nationwide and the different ways that they're designed, and taking a look at the different systems, right? We have a variety of systems. We have systems that have a state commission, and that state commission administers budget and may administer other resources. And then we have other systems, for example, the federal system, which is very much part of the courts and part of the judiciary. And taking a look at those systems, what are the best models? And we will be putting together a white paper exploring the current landscape of public defense independence throughout the country, and really what are some suggestions for the best models where you can have independence. I am not the one to come up with this, but I have often said, right, that until public defenders can print their own money, we can never truly have independence. But there are best models, models that are working more effectively than others. And the purpose of the task force is to really just understand, educate, and push for change throughout the country when it comes to public defense independence.
Thanks, Keisha. And so I want to start to dive into some of these little pieces because, as Kyle mentioned, when we think about independence, it often takes a backseat to a lot of other things we think about, in public defense. But really, it's at the cornerstone of everything else that we can do. And so I want to turn to Pam Metzger. Pam is the executive director of the Deason Criminal Justice Reform Center at SMU Stedman School of Law and a national expert on Sixth Amendment issues. And Pam, I want to talk about one of the kind of those foundational ways that independence really shapes public defense systems is actually in the leadership of those individual offices. Can you maybe share with folks a little bit about what that issue is and kind of what it's starting to look like across the country, some of the ways that it's really kind of reared its ugly head for a lot of public defense systems?
Sure. And for context, we can think about public defender independence structurally, particularly for statewide systems. We can think about it at kind of the line defender level. But you're really asking about that middle tier where you've got a chief defender who's running a program or a managed assigned counsel program, someone who's in charge of administering the day-to-day operation of the delivery of indigent defense services. I think the place where we've seen this most sharply in relief, obviously, is in Louisiana, where over the past 2 years, there has been a valiant and ultimately unsuccessful fight to save the job of 5 district defenders whose common sin was having appeared in public to testify against what the state public defender wanted in terms of both funding for lawyers, compensation plans, as well as ways of delivering capital contracts, et cetera. And we saw a system very much owned and operated by the governor and his hand-picked state public defender. And as a result, 5 chief defenders were terminated. Their contracts were not renewed. And I'm going to flag that I think it's very difficult to disconnect this issue from the issues that surround race, gender, and other kinds of difference in advocacy. It is not an accident that 3 of the 5 people whose contracts were terminated were women, that one of them is a Black woman, and there's another Black woman who did not fight to save her job, but was also terminated. And so that's an extraordinarily high percentage. I think it's almost half of the women who are chiefs in Louisiana. What that does down the line, I want to stress, is it signals to the defenders below that their advocacy, their unrelenting, unabashed advocacy for their clients is not going to be tolerated, that there's a close eye on them, and they're not going to be allowed to do their work the way they need to, much less speak out in public.
So, Keisha, I want to maybe come back to you for just a moment because you sort of previewed a little bit, but you personally experienced that, right? Where there was this close connection to what you and Dean did in terms of advocacy that writ large was on behalf of your clients and an issue that was important to your clients and the impact that it had. And if you could maybe share with folks a little bit about what that involved and some of the downstream consequences of connecting public defender advocacy opportunities with public defender independence.
Yes. So the Montgomery County Public Defender Office in Pennsylvania, that's the 3rd largest public defense agency in the Commonwealth of Pennsylvania. There are 67 counties in Pennsylvania, and the organization I'm chief of now, the Defender Association, is the only independent, I'll put that in quotes, independent public defense agency. In the 66 other counties, the public defense office is a part of the county government. And so when we came on board in 2016, we very much knew, and in fact, Dean Beer was told these exact words, that you serve at the pleasure of the commissioners, right? And not much more was said, but the idea was, and certainly his feeling was that he had to answer to them in terms of how he was going to lead that office. That said, Dean and I, took that under advisement, as you say, in court or judge speak. But that didn't stop the advocacy that we wanted to do in terms of how we were building the office and the systemic issues that we were very, very, very focused on changing. And that range from bail practices and pretrial detention all the way up to some issues that we were challenging with the ACLU about probation and sentencing. We filed an amicus brief in the support of the ACLU litigation. We filed that brief February 3rd of 2020. And on February 26th of 2020, Dean Beer and I were fired at 10 a.m. and 10:30 a.m. By the county commissioners. And most public defender offices in Pennsylvania, your office is physically in the space of the courthouse. And so you can imagine what that looked like, that chilling effect of having your chief defender and your assistant chief defender literally escorted out by a sheriff with a box of our personal items in hand and walked through an entire courthouse with not just our staff who were devastated, physically and emotionally devastated, but also the prosecutors and the judges and the police department and the sheriff's department. Right? We were walked through that courthouse. The 4 years that Dean and I led that office, we knew every time we did some level of advocacy, whether we were pushing for internal increase in our budget or we were pushing the commissioners and the courts and the district attorney's office to change, some pretty horrific and concerning practices when it came to our clients, we always felt that our positions were threatened. And we filed the brief, and Dean was told by the president judge and the commissioner's lawyer that he should have run the draft by them before it was filed to get their thoughts and their approval before we filed an amicus brief, which is one of the most boring parts of the work lawyers do, right? This is maybe the only time an amicus brief has been controversial, at least in the public defense sphere. And we were told if we did not withdraw the brief, then there were going to be consequences. And those consequences reared their head on February 26th when we were both fired.
And I think, Keisha, I want to maybe just tease out with you a little bit, because it's that connection between if somebody, right, Pam had described where you guys are sort of that middle tier. If we think about a system, there's some kind of leadership, there's some piece in the middle of individual office leadership, and then the line defenders themselves. And when we start tying advocacy or having to run advocacy decisions by other people who may control our agency and our leadership, some people may say, well, but aren't they your boss? Shouldn't they have that kind of say? And what right? How do we respond to that type of challenge when folks raise it?
Dean and I were very, very strategic in terms of talking to our staff about really what their first duty was. And it wasn't in just how, we talked to the staff, it really colored everything that we did as leaders in terms of how we recruited. When we got there, half of the public defender office, I would say half of our staff were legacy hires or political hires. And, spending 4 years really building up what a mission and the core values of a public defense system should look like, and the fact that our first and only duty of loyalty is to our clients and to their advocacy and to the systemic advocacy challenge in the criminal legal system and the juvenile legal system, that was going to be our first and foremost priority. And we did that from day one in introducing ourselves, not only internally, but externally. And so it was 4 years of a lot of tension between us and the judges, and a lot of tension between us and the commissioners who funded us. Not only did we serve at their pleasure, they funded the organization. But there were times when we knew after every big instance, whether it was a brief or whether or not they knew we partnered with the ACLU and we were providing data to the ACLU, on op-eds that we published, or quotes when we were quoted in the newspaper. Every time we were there was a bit of a slap on the wrist and you really should have told us, you really should have talked to us. We could have worked this out, or we would have addressed this if you had brought it to us, earlier. But we really didn't think that it was our duty, and it is not, as public defenders, our duty to get buy-in or permission or editorial input on the work that we were doing on an individual basis or on a systemic basis. And so we took that in, and we proceeded to lead the office that we wanted to lead and build, with fierce public defenders who, again, only focus and allegiance and loyalty is to the clients that we represent.
So, Pam, I'm going to come back to you because, everything we're talking about right now, often we think about as sort of those institutional defenders. And there is maybe this layer of protection and structure because those defenders have supervisors and leaders and systems that they're working in. But in a lot of places, public defense really is provided by contract attorneys, court-appointed counsel, who have a much more often direct, I'm going to use the word relationship loosely, with a court or some other authority that is appointing them or creating contract. And can you talk for maybe just with folks a little bit about how that looks differently when we start thinking about that individual attorney relationship?
Sure. And I'm sorry Melody isn't here for a lot of reasons, but not least of which is I think she would have said that this is a place where we see the lack of public defender independence at the federal level in really clear, excruciating detail. We see judges declining to approve vouchers, judges refusing to authorize investigation funds, judges punishing lawyers for vigorous advocacy by over and over again cutting their vouchers. It's an unconscionable incursion into what the lawyer's obligation is. But without greater independence at the federal level, it's very difficult to combat it. At the state level, I think it's far worse because most court-appointed systems, with the exception of managed assigned counsel systems, are highly unregulated. These are what David Carroll often calls non-systems, right? That there is no systemic way in which appointed counsel are managed. Contract lawyers are rarely provided with any kind of independence. And so what we see is lawyers on a day-to-day basis battling within themselves. Can I do this thing on behalf of client A, or am I going to get shut down tomorrow when I do it for client B? And unlike a line defender in a fully staffed office, they have no one they can go to say, will you back me here? They have no one they can say, you know what, maybe you need to cover tomorrow because this judge wants to kill me, right? There's very little institutional support. You add to that the fact that cases are doled out or imposed, depending on what kind of a system you're in, based on who's in favor. I've worked in systems where you got cases by buying your way in through judicial campaign contributions. And I've worked in places where you were punished for not giving contributions by being assigned a case. So the economics of this differ everywhere you are. But it's very clear that those lawyers lack any protection. And ironically, those are the lawyers in many ways that public defenders need to look to help establish institutional independence. Most of these folks have other practices. They're in civil court. They speak to the larger bar. If they're empowered to talk about independence and what they see in criminal court, that message gets out beyond the criminal court to the civil bar and to folks who really will, I think, appreciate the injury that's being done.
So I'm going to take full advantage of that nice gentle pass off to talk about messaging. And I want to bring into this conversation Charlene Grace. And so Charlene is the senior policy advisor for the Cook County Public Defender Office, which has a long history of doing messaging and advocacy around what are often really challenging legal system issues. And so Charlene, I want to have you share with folks, how do we message effectively around this really more nuanced question of independence, when often, we really are, as Keisha highlighted, we're supposed to be that check on the government. We're supposed to be the thing that challenges the system. And to do that, we need independence, but that often means pushing back against the very system that we're working in.
Yeah, thank you. So one thing I would say off the bat, and my background, and especially recent work, really is in policy advocacy, legislative advocacy, those kinds of changes. So a lot of the conversations we're having are with legislators, but that includes, other decision makers like the governor's team when he's going to have to sign a bill if we pass it. It includes a lot of education of the press, which is simultaneously public education and education for legislators. To a certain extent, I think my biggest messaging recommendation is to think about your audience and what works with them, and don't be afraid to focus on different things depending on who you're talking to. We really used a bunch of different strategies. In Illinois in particular, one of the things that our legislature feels in general, but especially right now, is that we're progressive and we're leaders, and we've been a national leader on criminal justice reform. So something that was very compelling to legislators in that context was how much of an outlier we were in Illinois. Just the constant refrain that it was only us in Mississippi that allowed local judges to appoint and remove chief public defenders without any other oversight, involvement, set terms, anything else. So that kind of outlier, and then the specific connection to Mississippi, which there's a sort of long historical connection between Chicago and Mississippi. But that was something that was really effective. We also talked about liability for the state. That was something the governor's office was interested in. We worked with the ACLU of Illinois, and they prepared the legal arguments about how independence fits into the state's lack of engagement in the public defense system, or lack of system, that the counties were left entirely to their own to set up here. We also, some legislators, depending on their backgrounds and their own experiences, are very ready to understand how individual actors, including in our case, the judiciary, who had sole control in 101 of the 102 counties in the state, could act badly in a kind of individual way, right? The retribution that's already been described in this panel. Others aren't looking for a bad guy, and maybe they like their chief judge, maybe they have a really great relationship with the chief judge in their county, and it's actually a challenge for our explanation if they have to believe that that judge is a bad actor capable of the sort of abuses of power that we've talked about in the independence context. And so in those conversations, a lot of what we tried to describe was the structural conflict that public defenders are in, the fact that even if they don't have a bad experience with their current chief judge, even if they haven't had this experience personally, that it's in the back of their heads. And that no person, but including people who have this professional and ethical duty to represent a client fully, should ever have to question that in balancing it with their own livelihood, their job, etc. And so trying to depersonalize it and make it very neutral was helpful for those kinds of conversations with legislators. That also worked very well with lawyers. It really depended on the lawyers. Some of the lawyers just had more insight into maybe the things that happen in court. And I think another thing with messaging, we really tried to, I don't want to say co-opt is too strong a word, but I think when there's all kinds of different assessments out there or evaluations, we tried to say, like, we're all trying to fix the same problem. We agree with these parts of this report from the court. We are adopting and moving forward with the recommendations made by the Sixth Amendment Center, where even when there's not 100% alignment, even when there's sort of independent parallel efforts to really bring them together so that you're focused on allowing decision makers to see some kind of consensus on the issue, I think. And we certainly talked a lot about national standards and best practices. And that kind of goes, I think, with the structural issues of just and then the national outlier issues. And the last thing I would say is just the personal testimony of public defenders, which was very hard because most of our public defenders are not in a position where it was safe for them to speak out. And I think that's where we saw really the role of public defense organizations. We saw that with help from Bonnie and NACDL coming in and giving that experience of a public defender, talking about the impact of the conflict, even though it wasn't someone practicing in Illinois, but also we, through a really extensive conversations with each other, the Illinois Public Defender Association was able to speak organizationally for its members who had experienced different consequences from a lack of independence. And that was also very important when very few actual chief public defenders and truly assistant public defenders as well felt comfortable speaking publicly about what their experiences had been in a system where there was not anywhere near adequate independence.
And I think that's right. Like that's the ongoing challenge, is often the ability to challenge the system and the structure is hampered because of the system and the structure. But the other thing we hear is this idea, and I think it comes up most in the context of the judiciary. We do hear it sometimes also, though, in the same context when we talk about, the public fisc, and whether it is the court's responsibility to ensure quality of representation or to ensure good use of public resources, the court or the community. We hear a lot of messaging around why public defense doesn't need to be independent, that it needs to be under someone's control. I think we would say that a fair bit of paternalism in this conversation when it comes to public defense. And so I want to talk just for a couple of minutes about some of that, and then we're gonna shift after that to talk a little bit more about then what are some good models and how do we effectuate that real change to happen. And so Keisha, I'm going to start with you a little bit. And some of these are, arguments that we hear a lot are around the court's job to ensure quality of representation. And since the court wants to make sure there's good representation, isn't it appropriate that the court or somebody else, right, be there to supervise or monitor or in some way control public defense representation?
Not when we have the adversarial system that has been designed and is functioning exactly the way that it has been designed, where there is a complete imbalance of power. I mean, that adversarial system, we play a significant role in that system, and we come into the system with horrific under-resourcing and understaffing. And significantly higher caseloads and workloads. I am in a jurisdiction with a progressive prosecutor. That's a whole other CLE about my thoughts on that. But I always get really angry when he comes into the courtroom and says, well, here in Philadelphia, you have 75% of the cases and I do 100% of the cases. I'm the prosecutor. And so therefore our funding can't be aligned. And then I point him out to every single area where his office is significantly more resourced than ours and a higher funding, and the grant funding and the ability to fundraise, and the fact that every legislative body really defaults to, if we're going to address criminal justice and achieve public safety, then let's look to the prosecutor or the police to be able to do that. And the public defender is often left out of that equation on a funding basis and on a policy recommendation basis. I think public defenders, it is paternalistic. I have said that word to judges here in Philadelphia and in Montgomery County, that we are best situated. We know our clients. We can tell you everything about our clients and how they got to the system and all the systems that failed and all the interventions that failed, which is why we have them as clients. And we are the best knowledgeable about public safety and the best knowledgeable about what our clients need, and also what that advocacy needs to look like. And we have, outside of all that, our clients have the Sixth Amendment right to counsel. They have a Sixth Amendment right to to effective counsel. And you cannot be effective if you are answering to one or more masters, whether that be your county commissioners or your state legislature or the prosecutor or the judges. We have one and only one person that we are, we have to answer to and we have to zealously advocate for. And that is not just because it's best practices, but it's a constitutional guarantee.
So Pam, one of the pieces we do hear a lot about is that there's a responsibility to control the funding, right? And the proper use of resources, and that's the reason the court should have some oversight. You had mentioned, for example, judges reviewing vouchers, right? And especially with the private bar, we see this probably more so than with institutional public defenders, that sense of obligation to just make sure public funds are being used well, and that the court has that responsibility. And how do we address that, right? How do we really think about responding back to that type of a claim when it comes to thinking about independence?
Yeah, I'm always overwhelmed that no one feels the need to oversee how prosecutors spend their money or police departments spend their money. It's really shocking to me, the way that there's not even a pretense, right? That this is somehow a problem that we have across government. It's very clearly targeted at folks who are quote unquote slowing things down or making things difficult, which is in fact our job. Right? That is the job in many ways. I think that many years ago I had a judge tell me that if he was doing his job well, there didn't need to be a public defender in the room, and so he was overseeing the spending because he already knew what was happening. And I think part of this lies in a matter of education and trying to bring some of these judges into the understanding that there's a reason that Gideon exists, that we're no longer in that Betts versus Brady era, and that we are in essence liberating them from an obligation that they can never honor, right? Which is to guarantee an effective defense with someone with whom they do not have a confidential and privileged relationship. The second piece I want to say, though, is that there is a place where judges have an obligation, and I'm going to tell you where that is. When they see terrible representation, when they see lawyers who don't show up, who don't talk to their clients, where they're getting letters over and over and over again complaining, those are the places where judges should be worrying about how the money gets spent, and more importantly, should be worrying about what kind of defense is being delivered. Those are the ones that you refer over to a bar association or to a chief. But I think, trying to bring the judiciary along is very much what Sherilyn said. You have to say, Judge, I know it's not you, it's that other guy. We worry about that other judge over here. I mean, you yourself in your practice must have dealt when you were a lawyer with some very difficult judges who didn't like a strong, excellent lawyer like you were. But it is a very, very tricky problem. I think nowhere is this more clear than in the area of investigative services, where it is unconscionable that public defenders are forced to ask judges ever for funds for core services like investigation. I think that sense is changing in staffed full-time public defender offices, where it is not changing, and I think is proving to be a more intractable problem, again, is for contract defenders and appointed counsel.
So, Sherilyn, I want to come back to you because I think, when we think about how do we talk about this, and we've talked about how do we address funding, and this is unfair. You're not overseeing prosecution spending the same way. You're not overseeing, prosecution decisions about how to practice. But the fact is, a lot of times folks will frame this and say, in public defense is just, it's not seen as popular, right? Or our clients are not seen as a meaningful constituent. I think somebody had shared with us in the Q&A, often we might turn to things and talk about, like, am I being effective in my representation? And, is that a way to message it out? But how do we really, sort of frame that discussion and respond to the idea that, the courts may be here to protect us, the defense, because otherwise we have no other advocate, right? Nobody else would advocate for us if it weren't for fill in the blank, the judge, the county commissioner, trying to make sure that we're protected.
Yeah. I think Keisha and Pam have talked about a lot of the stuff that I might want to say. I think we did hear this a lot in our push for independence over the last several years in Illinois. And we've heard it a lot from public defenders who are like, well, my judge is the only person in charge of my budget and hiring at this county who knows what the Sixth Amendment is, right? The judge is so much better than the county board in my small rural county. And that is something that we heard defenders when they talked to us about that. And it's not that public defenders don't want champions for our work, and it's not that we don't want allies, but it's about how much power is invested in one role, and the relationship of that role to our work as defenders. So I think one of the things we talked about is just the challenge of judges being in what's supposed to be their neutral decision-making role inside the courtroom, and then stepping outside and having other claiming to have this other role where they're champions for our offices. We talked a lot about in many Illinois counties under the status quo, because the reform that we passed in the spring is not in effect yet. So under the status quo, and the system that we have set up for change now, we talked about how many defenders have to go to their judge to ask for approval to hire an expert because it's coming out of a budget that the judge controls. So they're very literally controlling these specific defense strategies in individual cases, as well as the office's larger budget. So I think one thing that we fall back on is something I think, Pam, you were just sort of talking about, which is preventing judges from really being in a role that is not appropriate for them, given all the hats they wear, which is not primarily a county budget administrator hat. So I think that's probably the biggest emphasis now. And I think part of what we've said is that we want to create a system that will enable us to develop other champions of public defense, right? We will bring in appointed members of a statewide commission who are committed to this work, will learn about it, will be able to talk about it, will be the champions and allies that we do want and need, but also that giving public defenders independence allows us to be our own advocates and champions in a way that we can't be now. And so I think that's the hope and the sort of promise that we as a defender organization have made to ourselves and each other, in relation to not having the judges as our champions anymore.
Right. So that I want to, as we kind of come to the back end of this, I want to start talking about how do we then both affect change, and then to really talk about what are those things that do look like good and independent systems. And I think, Charlene, that jump off point of none of this stops a judge, a county commissioner from being an ally, and from advocating positively for us is not the same as controlling. And that ability then to use them still to facilitate change. So, when we think about how change happens, there are usually kind of three big buckets we think about. They happen through litigation, they happen through legislation, or they happen through, some type of policy voice. And so I want to start with litigation. It's often, I think for all the attorneys on the call, right, it's our go-to. If I want to solve a problem, let's go to court and fight about it. And so I want to talk about some of just sort of broad strokes, what litigation has often brought us in this space. And then we'll talk a little bit, Charlene, about the legislative route that you all were able to take so successfully in Illinois. And then we'll talk about the ABA policies, and then some of those recommendations for what sort of makes good public defense independent systems. So we'll go Pam first on some of the litigation that we've seen in this space.
Yeah, so I think litigation has been a very mixed bag. And oddly, some of the most successful litigation has been on behalf of individual defenders who have lost their job. You can look at Steve Singer in Oregon, for example. But there had been absolutely no institutional benefit. Jessie Campitt lost her job summarily, a year and a half later. These individual litigations, and I wish Charlie Gerstein was around to talk about those. Right?
He was my attorney.
I know he's everybody's attorney.
I can talk about Hudson versus Montgomery.
There you go. I just sent him another client. I think independence litigations as standalones then become very difficult, and they get framed out usually in terms of subsidiary issues. So, for example, litigations over the right to decide which lawyer within your office is taking a case, right, becomes the frame for a certain kind of independence litigation. There are the right to file, the right to speak out litigations, which Keisha obviously is in the best position to talk about. I'll also flag that I think there are litigations we have not yet touched and we should be thinking about that relate to the relationship of prosecutors to the judiciary and the way in which that relationship sandwiches defenders on independence. We haven't gone there yet. I think there's a lot of room for us to be thinking about how to go there. I don't know that that litigation is the most effective route. And I will say that in the current climate, with what I believe are very real threats to roll back Gideon, I think it's wise to be cautious about litigating in any frame that might allow people to say, well, we can solve this problem by removing the right to counsel from this particular piece. So whether that's advice about collateral consequences, whether it's pre-indictment representation, whether it's something about, kind of sentencing enhancement, I think we need to tread lightly about not teeing up situations where people can find a solution that involves scaling down the right to counsel rather than upping independence associated with it.
Charlene, let's talk about maybe what's been, I think, in Illinois, a great example of using a very different tool, which was, I think a combination of some report and using that as a foundation actually to bring about legislative reform. So can you share with folks, and I don't know that everybody is familiar with actually what you guys have accomplished in Illinois in the FAIR Act?
Yeah, thank you. I just, we're putting some links if people want to learn more, read more in the background in the chat. But the FAIR Act stands for the Funded Advocacy and Independent Representation Act. And it's something that the Illinois Public Defender Association developed in partnership with advocates at Northwestern Law and community-based advocates, and had been working on for a couple years. Our process for reform in Illinois really started with credit to the Supreme Court for bringing in the Sixth Amendment Center to do an evaluation of trial-level criminal defense in Illinois. It was before COVID, and their report came out in 2021. And when it came out in 2021, it just kind of came out on a website and stayed there. And then we were like, well, this is really concerning, and it's a really big opportunity, and there's not anything coming through, it seems like, to use the findings of this report. So let's do something with it. And then the Children and Family Justice Center at Northwestern Law School started pulling together data, and actually put together sort of on a shoestring with volunteer PhD students and law students and a lot of FOIA and hard work, basically a caseload study from Illinois defenders, and looked at the allocation of defender staff, the number of cases, types of cases, comparing defense funding to prosecution funding, and worked with our office and others on an initial draft of a piece of legislation to try to correct the independence deficiencies that we saw as very closely connected to the ability to advocate for funding and other resources. And that sort of kicked off a multi-year process of talking to defenders from around the state. So I'm on the board of the Illinois Public Defender Association, and we worked with the Illinois Council of Chief Defenders to develop a bill that corrected the problems we saw, that listened to defenders as part of the process. Because one of the things that happened along the way was sort of as this community-driven effort was developing, there was also simultaneously a court-driven effort. And the court-driven effort really kept the court central to all of the decision-making and planning. And the court, along the way, I think in many ways maybe even planned to get to a similar place to what we were proposing. But what they put on paper and introduced in the legislature was essentially the Illinois Supreme Court will start a public defender administrative support office inside of our it owned the court's administrative office, and trust us, we got you. And defenders were like, well, based on the past experience, this isn't something we feel comfortable just leaving sort of in the court's black box. We want defenders to have a leadership role. We want there to be more public engagement. We want a date at which we get independence and structural changes to a very challenged system in Illinois. And I want to make sure I answer the questions you wanted me to.
You're doing fine. I'm not
I
sure.
haven't said what the bill does, but I don't know if that's helpful. We might have time for that.
I think as we start to talk a little bit about sort of like what are those good hallmarks of independence, I think we're going to talk about some of the specific features of it. But I do want you to touch on for just a second to help maybe fill that space that Melody would have filled for us, which is the federal system. Because I think, as you guys were going through your work, there was a lot of discussion about, well, can't we just use the federal system as a model, right? Can't that sort of address this? And what you're describing the judiciary was proposing, I think a lot of us would feel like it was very much like the current federal system, in which the defense function lives very squarely within the four corners of the court, with the court exerting that type of control, and how you guys maybe found some unexpected allies or some unexpected adversaries in kind of levering that part of the discussion.
Yeah. I will say one just very important dynamic in Illinois with thinking about where a future, because one thing there was consensus on was we can't have 102 county-based systems. We need a state office. It doesn't mean the state office is going to be the only office, right? I work at a county public defender's office. We're not going anywhere, but we do need a state office if we are going to be able to attract attorneys to rural areas of the state. We need a state office if we're going to be able to train and support and pay those attorneys in competitive ways. We need a state office if we're going to have investigators, specialists, social workers that are available to all parts of the state. We have those things, and we're one of the only offices in the state that does. And other clients of all public defense offices in the state deserve those resources. So we knew the court, the advocates, everyone was like, there needs to be a statewide office, there needs to be support. But one of the dynamics in Illinois was that it's a very pro-labor, pro-union state, and employees of the court itself, the administrative office of the court, are not subject to the Labor Relations Act under the state, so they couldn't be unionized. And that was, for example, when we started talking to the unions who represent our public defense staff in Cook County, something that became really important, right? The possibility that future state public defenders could be organized, could be part of helping ensure that they have great benefits and competitive salaries, which is something that's really benefited our office. So that, I think, the role of labor was something that was really important, both in certain county conversations, but also with the independence of a statewide office and how it interacted with all the other structures of Illinois law. And I'm sure there's a million others, but I know we want to talk about.
You're doing fine.
Other
yeah.
things.
So let me. I'm gonna grab somebody. There were a couple of questions up here. There's one that I think is really pertinent to what we're talking about now, and I'm going to open it up to the group and see if anybody feels comfortable about answering this, because I think this is a real challenge, which is sometimes what we're seeing is line defender independence. So raising challenges by line defenders about their individual workloads, about unionization, about sort of whistleblower claims that individual line defenders are making towards their management, and that measure of independence, and how that often is really maybe seen differently, or as a conflict, or as threatening to defender independence in a way that is different than we think about sort of big system independence, or independence for the defenders to advocate for their individual clients. And so would love to, if somebody feels confident, Keisha, you are my go-to on this, because I think you're probably closest to this issue. around how do we balance those two, or allow those two to coexist?
I want to say really quickly, litigation is an avenue, but I don't think we should underestimate the power of organizing. And I think very much a part of what needs to be involved in public defense advocacy and systemic change, particularly around this issue, is community advocacy and community organizing. And note we got fired February 26th of 2020, and everyone on this call knows what happens just 2 weeks later. And a week after we were fired, because we had spent 4 years working with organizations like the ACLU and a number of other organizations, building relationships with the local law schools, politicians, churches, different advocacy components that came together and were calling for our reinstatement. And I do think, but for COVID, I really do feel like we would have been reinstated. The one silver lining, there have been many silver linings of our termination, but the one is that Montgomery County now has an independent advisory board, which is a robustly composed advisory board that hires the chief defender. They still control the budget, right? So quasi independence, but it was shining a light again on the chilling effect of our advocacy, both in court and on systemic issues, that pushed the commissioners to establishing that advisory commission, which now oversees or has some oversight power over the defenders. And I think, again, emphasizing that strategic advocacy, one component of that always has to be community relationship and organizational building relationships, and just straight old fashioned organizing to be able to do that and support public defenders when we need it. But I think, the day-to-day, right, when we think about what a line attorney has to face and has to go through, I think, ensuring that as chief defenders and in the leaders of our organizations that we are having that conversation with the courts about what our advocacy is going to look like and what it is not going to look like. And though entities like the Judicial Conduct Board here in PA are not robustly funded, we have outlets again to emphasize why we need to do this advocacy and why we need to speak out. Not just in our individual cases, but for system issues when it comes to criminal justice or juvenile justice legal reform. And I think it has to come from leadership, knowing that our line public defenders can do the advocacy that they are constitutionally required to do with our support. And there is at least once a week when an attorney of mine is going to be found in contempt. It happens weekly here in Philadelphia. And when I rush over to court and I bring someone from our appeals unit with us, and we firmly are always in the zone of advocacy, it is just that continually reminding judges in particular that we are in our lane, and what are redefining and re-educating about what our lane is and the fact that this is the lane that we are going to occupy. Now, when it comes to funding, that's an entirely different situation, right? So I'm in a city where 99% of my funding comes from the city of Philadelphia. I know that what I say or do may impact the funding that I get. And so I have to be very strategic about what I say and do. And again, going back to community organizing, who are the people that I'm going to go to who can advance the important issues for us without it coming from me and the office? Because if it comes from me, there's going to be an effect. If it comes from one of the big faith leaders in the city, it's going to have a different impact.
So what I'm going to do, we've got just a couple of minutes left. I'm going to ask each of you to think about one thing, maybe, and Charlotte, I'm just going to warn you that I'm going to start with you, is to think about one of those things that you see is a good safeguard to public defender independence. So maybe thinking about something that you guys really, fought for in your legislation that was important, or something that you see as a good structural piece. And then we'll go Charlene, we're going to go to Pam, and Keisha, then I want you to close with maybe some of the things we're starting to see from the ABA recommendations about sort of what that good, better, best public defense system looks like. All right, Charlene. No pressure, but
I'm just going to start with the basics. The simplest thing was really like appointment for set terms and removal only for cause. Also for us, it was about getting an application process and qualifications. I mean, we, outside of Cook County, Illinois has been operating a system in which there is no requirement. There's an application and there is no qualification other than someone be licensed. So we had people appointed as chiefs their first year out of law school. We had people appointed as chiefs because the judge picked up the phone and said, "Do you want it?" And so that kind of transparency and then the ability to know that you are protected with just cause removal was really the most basic thing. And I'm just going to say one more thing about Illinois. It's not directly responsive, Bonnie. I want to say, like, one of the things I sometimes heard from national advocates we talked to was like, oh, the public defenders aren't going to support this. Like, every public defense reform that's happened has happened over the objection of public defenders, as though like we are not committed to the great service that our clients deserve and are entitled to under the Constitution. And I think one of the things that we're most proud of in Illinois is that it took a lot of work and it took a lot of conversation internally, but that we did this in a way that not every single public defender in the state, but the major public defense organizations and the majority of public defenders who are actively involved in this conversation about reform ultimately supported.
All right, Pam, one thing that you think is a
One.
good one, maybe two. I want to leave Keisha a minute.
Okay,
Two.
give me two.
Two.
Assignment and appointment should be independent of the judiciary and the executive and should be managed by someone, for example, a managed assigned counsel program leader who can stand between individual appointed counsel and contract defenders and judges. And the second thing I want to say is Texas. You need a statute like Texas Criminal Procedure Article 26044, which guarantees that a chief defender cannot be fired for, in good conscience, refusing to take more cases.
Fantastic.
Got to
All
two.
right. You did get to. All right, Keisha, you want to close things out with what we're seeing from the task force as we start to kind of identify what are those models for good defender independence?
Some of the best models we're seeing, and I think Michigan having one of the better models, where you know, Michigan is a very large state, and so there's a Michigan Indigent Defense Commission, but that by statute, the funding and the funding mechanism is housed. The funding is allocated to the Indigent Defense Commission, and then the Indigent Defense Commission is the one allocating the funding to different county defenders. So that's one of the better models. There are no best models that we are finding out on the task force, that there's not one. If I were queen for a day, I could design my own model, but we don't have any current existing models that are perfect. That one comes close to best recommended practices, that you really want that layer of protection between the public defense agencies and that chief defender and their team, and not just the state legislature or county legislature, but also the courts and the prosecution. So that is one of the best models. A mechanism by which you can allocate and distribute funding, however that application or mechanism or grant system is designed, that is transparent, and that there's going to be some checks and balances in terms of what is allocated and how in that process.
Fantastic. So I want to thank all of our panelists again. Tremendous discussion. I think a really challenging issue and one that has a lot of moving parts to it. But I want to thank everybody for this and thank everybody for joining us here today with our SCJN.